Good morning, ladies and gentlemen. All right. Those of you who know me know I often say I come from a call and response tradition. So when I issue the call, good morning, I like to get a response. So we'll try this one more time. Good morning, ladies and gentlemen. All right. Participation points duly noted. My name is Patrick Sims. I'm the Vice Provost and Chief Diversity Officer here at the University of Wisconsin-Madison. Thank you for being with us today. I'd like to begin my remarks by acknowledging and honoring our local First Nation, the HoChunk, on whose ancestral land we are gathered today. The name HoChunk means people of the big voice, and today we are here to honor all of our voices. The Diversity Forum has been held for 19 years, y'all. That's a round of applause right there, 19 years. Since 1998, and I'm proud to say that it has become one of the major events for the university during the fall semester. More than 700 individuals are registered for today's forum, and we took a different approach for the second day, so we capped enrollment at 200, but we've exceeded that by almost 75 individuals. So we have about 275 folk registered for tomorrow's focus, which will be on mental health support and wellness. So we're really excited that you all are here with us and you're interested in learning more and engaging around issues in diversity and inclusion. This year's theme, Together Building Cultural Capacity, includes a program with many special elements. During our breakouts, the town hall, and the lunch session, we're here to serve you. Now, to get the day started, it is my distinct pleasure to introduce, as I like to say, my boss lady, the Provost and Vice Chancellor for Academic Affairs, Sarah Mangelsdorf. Provost Mangelsdorf began her role at UW-Madison in August of 2014 after 6 years as the Dean of the Judd A. and Marjorie Weinberg College of Arts and Sciences at Northwestern University, where she was also a member of the Department of Psychology. Prior to Northwestern, Mangelsdorf served from 2004 to 2008 as the Henry E. Preble Dean of the College of Liberal Arts and Sciences at the University of Illinois at Urbana-Champaign, and was the first woman to hold that position. So kudos to Provost Mangelsdorf. The Office of the Provost provides guiding vision and framework for overall academic leadership and administrative management of the university. Her office's mission is to administer programs and policies that benefit academic staff, faculty, and students, and to foster collaborations among campus colleagues that will enhance and broaden academic life at the university. Provost Mangelsdorf has a wide and broad set of responsibilities over numerous campus-wide initiatives, including the diversity framework, which I collaborate with her on, and which many of you have also helped us collaborate on. So without further ado, please a warm welcome for Provost Sarah Mangelsdorf.
Well, thank you, Patrick, for that kind introduction. Welcome to all of you. It's really wonderful to see so many people here today. Thank you all for coming. I hope that every one of you will leave this conference with new ideas, new connections to colleagues, and a new sense for the role that you can play in making University of Wisconsin-Madison a welcoming place for all people. I hope you will also leave with important messages and new knowledge from one of our nation's leading Native American rights attorneys, Walter Echo-Hawk. Since 1973, Walter Echo-Hawk has worked at the epicenter of a great social movement alongside visionary tribal leaders, and you'll be hearing from him soon. When we gathered last year, UW-Madison was taking its first ever campus-wide student campus climate survey. Over 8,600 students, or about 21% of our student population, took the survey. Since April, a campus climate survey task force has been reviewing results, and we released results this past week. This noon, we invite you to attend a special luncheon presentation to learn about the task force findings and recommendations. The good news is that 4 out of 5 students report experiencing a welcome and respectful climate at UW-Madison. Unfortunately, and not too surprising, differences exist among subgroups of students. In particular, students from historically underrepresented and disadvantaged groups report experiencing a less favorable campus climate than majority students. The luncheon plenary session will give us an opportunity to talk about these disparities and what the task force has recommended as next steps. Towards the end of the day, our diversity forum will feature a panel entitled Undocumented and Uncertain, a town hall discussion on Wisconsin Dreamers. As many of you are aware, President Trump announced recently that his administration would begin phasing out DACA, which stands for Deferred Action for Childhood Arrivals, the federal program that has provided protection from deportation for young people who entered the country as dependent minors without documentation. Estimates place the national number of DACA immigrants who were children when they arrived in the U.S. at approximately 800,000. Estimates are that there are around 7,600 living here in Wisconsin. I expect that we will have an engaging discussion, and I encourage you to stay for the last session today. This session, along with 8 breakout sessions that are described in the forum brochure, are all discussion topics that you won't want to miss. Our campus greatly values diversity. Diversity in all its forms makes University of Wisconsin-Madison a better place to work and a better place to learn. We value educational opportunities that help students learn to work and live with people who are different from themselves, honoring not just racial and ethnic diversity, but socioeconomic, gender, political, and ideological diversity as well. We are working to provide increased access to first-generation students. Our new Badger Promise program offers free tuition to first-generation Wisconsin transfer students to help them pursue their dreams of a 4-year degree. Our goal is to provide an outstanding Wisconsin experience to each and every student, where the concept of a student's Wisconsin experience embodies the Wisconsin idea and is steeped in our long-standing institutional values, the commitment to truth, shared participation in decision-making, and service to local and global communities. And while we're doing this, we also have to be sure that this is a community where people want to live, work, and learn. That's why the Campus Climate Survey is a critical step as we implement our campus diversity framework. We want to understand how faculty, staff, and our students experience this place and what we need to do to improve the climate. But this conference isn't only about focusing on needed improvements. It's also about celebrating our achievements and accomplishments. For example, last year's applicants were up by 14% from students of color. Our second-year retention rate, just reported this fall, for freshmen returning for sophomore year is above 94% among underrepresented students for the 4th year in a row. This is the best it's ever been in the history of this university and is far better than a lot of our peer institutions. Even better, the 6-year graduation rate for underrepresented students reached 80% for the first time ever in the history of the university. And the hard work that we've done to recruit and retain more diverse faculty is paying off. I'm happy to tell you that 24 of our 105 new faculty hires this past year are people of color, and about 19% of our faculty overall self-report as being members of racial and ethnic minority groups. None of that, we still have more work to do, but this is real accomplishment. And none of this would have happened without the dedicated work of people all across this campus. And I know many of you are here today. So thank you for all that you have done and will continue to do to make University of Wisconsin-Madison a welcome, respectful, and inviting place for all. Have a wonderful diversity forum.
Thank you, Sarah. Today, before we get to our keynote speaker, many of you are familiar with the program my office runs, recognizing outstanding women of color. We'd like to take this opportunity right now to recognize and announce who the individuals, the recipients will be for this year's award ceremony that will be held in the spring semester. The UW-Madison Outstanding Women of Color Awards acknowledge and honor women of color among UW-Madison faculty, staff, and students, both undergraduate and or post-baccalaureate, and in the greater Madison community who have made outstanding contributions in one or more of the following areas: social justice, activism, and advocacy on behalf of disadvantaged and marginalized populations, community service, scholarly research, writing, speaking, and/or teaching on race, ethnicity, and indigeneity in U.S. society, and community building on or off campus to create an inclusive and respectful environment for all. This year, we received 26 nominations for the honor, for this honor, who will be honored, as I mentioned earlier, in the spring semester. First, Christy Clark-Pajara, Associate Professor of History in the Department of Afro-American Studies, is a gifted and devoted teacher of both traditional and non-traditional students who frequently shares her profoundly relevant approach to African-American history with the broader community. Tausia Gonzalez, Assistant Professor of Special Education in the Department of Rehabilitation Psychology and Special Education, is a tireless advocate for individuals from marginalized groups on the UW-Madison campus and beyond. From student engagement to organization development to food justice, Beverly Hutchinson, Outreach and Communications Manager in the School of Medicine and Public Health, is truly dedicated to advocating for equity for underrepresented populations. And since her arrival on UW-Madison in 2013, Helen Lee, Assistant Professor of Glass in the Department of Art, has worked tirelessly both to create and exhibit her own artwork as well as to build an inclusive community in the art department and its glass laboratory. Barbara Nichols is a former secretary for the Wisconsin Department of Regulation and Licensing. And during her 60-year career, she's striven for more inclusive, diverse, and welcoming health communities in Dane County and beyond, with a particular focus on increasing the prevalence of populations of color and men in nursing. And last but not least, Brianna Young, a Posse Scholar and School of Nursing student, is currently in her senior year and student at the UW-Madison School of Nursing, where she serves as a STEM and School of Nursing student ambassador. Congratulations to all of our outstanding Women of Color recipients, and we look forward to celebrating you in February. Now, as many of you know, November is Native November, and I'm pleased to take this opportunity to introduce the HoChunk Bear Clan Singers, led by Mr. Gerald Cleveland and his 3 grandsons and his great-grandson. Mr. Cleveland? Thank you. Now it's time for me to introduce today's keynote speaker, Walter Echohawk. Walter Echohawk is a Native American attorney, tribal judge, author, activist, and law professor. Echohawk represents Indian tribes on important legal issues such as treaty rights, water rights, religious freedom, prisoner rights, and repatriation rights. His career spans the pivotal years when Indian tribes reclaimed their land, sovereignty, and pride in a stride towards freedom. As a Native American civil rights attorney since 1973, we were joking last night, that's 44 years. I was sharing with him that I was 2 years to be born after that, so I'm 42, so we've been at it for a while. And we marveled at how committed and dedicated and passionate he's been. He's been at the epicenter of great social movements alongside visionary tribal leaders, visited tribes in indigenous habitats throughout North America, and was instrumental in the passing of landmark laws, including the Native American Graves Protection and Repatriation Act of 1990 and the American Indian Religious Freedom Act amendments of 1994. He litigated in many epic struggles and has written extensively about the rise of modern Indian nations as a Native American author with firsthand experience, such as his groundbreaking book, In the Courts of the Conqueror, the 10 Worst Indian Law Cases Ever Decided in 2010. He also shared with me, if I could just give a sneak peek, you have another new book coming out, a story that is sort of an epic tale. So I won't say much more about that, but I got a chance to hear some of what his next efforts are, and I can't wait to see those as well. Thank you so much for being with us today. Please, ladies and gentlemen, a warm welcome for Walter Echohawk.
Wow, this is a lot of people here today. I just wonder if I'm in the right forum or not. Thank you very much, Vice Provost Sim, for your very kind and generous introduction. Singers, I want to thank you for those wonderful songs. It's my privilege to be in HoChunk territory here, the great state of Wisconsin. In years past, I had the privilege of representing some of the HoChunk leaders, the late Mr. Douglas Long, as well as the late Reuben Snake from Wisconsin as well, in a drive to go to Congress to get Congress to pass a law to protect the rights of the Native American Church to use peyote for religious services. And I had the privilege of representing this very fine people. And along the way, I learned that if you can't be a HoChunk Indian, the very next best thing is to be their attorney. But I do want to thank you for rendering those songs for us, Provost and Vice Provost. I commend you for putting on this wonderful diversity forum, and I'm grateful for each and every one of you for being here to participate in this forum. I'm so honored and privileged to deliver the keynote address for the 2017 Diversity Forum. And I commend you and your office, department, for bringing us together so that we can celebrate America's diversity, Wisconsin's diversity, and truly ours is a very diverse society. It's a multicultural society. Our land is home to virtually every culture known to man, and it is a multi-religious society that we live in. Virtually every religion under the sun is protected by our laws and social policies here in the United States, and we enjoy a multinational society comprised not only of 50 states of the Union, but 560 federally recognized Indian tribes that enjoy a government-to-government relationship with the United States government, often under treaties. And these governments, these Indian nations, including 11 here in the state of Wisconsin, are deeply embedded in our domestic political system. So the Diversity Forum gives us an opportunity to celebrate America's great diversity, and also to think about how colleges can best discharge their functions in higher education functions in such a diverse society. And it's my contention today that no diversity discussion in our country can be complete without thoughtful discourse about the first Americans and the indigenous issues that confront our Native American communities at home and on campus as well. Who are the Native Americans? What are our aspirations? What is our situation in the United States of America? And what issues confront Native Americans? This discourse, I think, is especially appropriate in the month of November, which is Native American Heritage Month. So my topic this morning is going to be informational in nature, but I do want to focus on a contemporary, cutting-edge issue that is now sits before Native America, and that is the question of human rights for Native Americans. So what I'd like to do here at the podium in the time that I have this morning is to share with you information on 5 subjects. Is that me? Am I beating up this mic? First of all, I'd like to share some baseline data about Native America in the USA today. Secondly, I want to define the term human rights for purposes of my lecture this morning. Thirdly, I'd like to examine the human right history or the Native American human rights experience in our country historically. Fourth, I will then examine a brand new human rights legal framework for defining the rights of Native Americans here in our country and the obligations owed by our great nation to its indigenous peoples in a human rights framework. And then finally, I'd like to end by talking about what can colleges do and educators do to help Native Americans obtain the full measure of indigenous human rights in our country. I feel like colleges are very pivotal and important organizations that can help foster an education climate to bring the full ambit of modern human rights to our Native peoples. And I want to talk about that before I end my remarks today. Hopefully there'll be time for questions and answers, and I understand I am to sign some books on this very subject of human rights afterwards. I'm very pleased to do that, and thankful to the bookstore for bringing a few books along today. So I'd like to just begin by stating that today, in the year 2017, is a very historic time for Native Americans because we stand at the dawn of a brand new era in indigenous history in our country, the human rights era. And this is a very exciting time because that is true not only for the more than 5 million Native Americans in the United States, but also for 350 million indigenous peoples around the world. Because indigenous peoples worldwide stand at the confluence of modern international human rights law, that is, UN human rights treaties and customary international law, and domestic law in more than 90 nations around the world that are home to indigenous peoples. And we can see way out there on the horizon this brand new human rights framework for defining the rights of indigenous peoples that is coming our way from the United Nations and from modern international human rights law, which has experienced a dramatic growth since World War II, not only in the field of human rights law, but also in the rights of indigenous peoples in the post-colonial world. So this has been brought to us by the United Nations landmark Declaration on the Rights of Indigenous Peoples that was approved by the UN General Assembly in the year 2007 after more than 20 years of work within the UN human rights framework. That was approved, as I say, in 2007 and then endorsed by the United States during the Obama administration in the year 2010. So this UN Declaration on the Rights of Indigenous Peoples is already technically a part of U.S. policy, but it remains to be implemented in our laws and policies throughout the nation. This UN Declaration shows each nation the content of indigenous human rights under modern international law and what the obligations of each nation are to its indigenous peoples. It lays out the content of those human rights, and it sets forth minimum standards that designed to protect the survival, dignity, and well-being of the world's indigenous peoples. And it asks each nation to implement these standards into its domestic law and policy in consultation with and in partnership with indigenous peoples. So the challenge that sits before us then is to work with indigenous peoples across the nation to fully implement these UN human rights standards into our American laws and policies. So this is a historic time. It's a very rare moment in indigenous history. It's been described by legal scholars as a jurisgenerative lawmaking moment in legal history for Native Americans. And you might ask yourself, well, why is this such a big deal? Why is this a historic lawmaking opportunity that we find ourselves in today? Don't we already have our Bill of Rights that define the rights of the person? Don't we already have other laws in place here in our country? Under our U.S. Constitution, don't we already have a comprehensive federal Indian law framework for defining the rights of Native Americans? But the problem is that human rights for Native Americans have always been beyond reach, to our tribal peoples in this country as a practical matter. And the current legal framework that we have, which is called federal Indian law, which provides the set of treaties and federal statutes, Supreme Court decisions that define Native American rights, is entirely bereft of the human rights principles. When the Supreme Court created this legal framework and set about in the young days of the Republic in defining the rights of the Indian nations, John Marshall and the court said we can't look to abstract notions of justice when defining Native American rights. We can't get involved in debates over morality when defining Native rights. We just simply have to take the law as we find it and apply it, which back then was the law of colonialism, which the Supreme Court imported in whole cloth here in the United States and used it for defining the political land and civil rights of the Native peoples in our country. The Supreme Court insisted throughout the 1800s that justice and morality have no place in this legal framework, and it sort of evolved a very strange body of law that makes no mention of human rights. And this has sort of created an amoral body of law that has a pretty high tolerance for manifestly unjust court decisions and legal principles regarding Native Americans. So our task, it seems to me, of this generation is to begin implementing and injecting the human rights principle into this legal framework here in the United States so that the first Americans can enjoy the same kinds of fundamental human rights as defined by modern international law that the rest of humanity already takes for granted. The Native American tribes are poised at this time, after reading this declaration, beginning to understand it, to begin marching forth here at the dawn of this new era to see if we can't enter into this human rights realm for the first time in American history. Just in September, in Boulder, Colorado, marking the 10th anniversary of the enactment, UN and passage of this UN declaration, a national project was created by the Native American Rights Fund, was announced, to coordinate a national social justice campaign to begin implementing these UN human rights principles that the Obama administration endorsed. Today, worldwide, 150 nations around the world have also endorsed this declaration, making it the new order of the day. So our tribal peoples are poised now to begin climbing that mountain. The Ackerman law firm, which is represented at my table here today, is going to be hosting a fundraiser in Chicago this spring to provide some seed money for this mother of all campaigns that I think Native America is beginning to embark upon. And I feel that colleges along the way can play a pivotal role in this social justice law reform movement that will improve the lives of some more than 5 million Native Americans. So I want to provide a little baseline information before I go much further into this human rights lecture. And I think baseline information about Native America in the USA today is necessary and helpful because there's an unfortunate information gap in the United States about Native Americans. Most Americans have never met a real Native American, have never been on an Indian reservation. We're taught very, very little about Native America in their schooling, and are not privy to any very much media discussion about our issues, contemporary issues. And most information about what most Americans know of Native America are simply stereotypes, that come to us from Hollywood. So this has engendered a lot of widespread ignorance about the first Americans, which I think is a very sad state of affairs and certainly a very dangerous human rights situation when this kind of lack of knowledge is embedded in the machinery of government. So I wanted to, I guess, lay the blame, if I may, on the doorstep of public education about great failing, I think, in our many of our schools around the country that just fails to include Native American history, cultures and values and issues, in our formal schooling of our young people. Also, I lay this problem at the doorstep of our public media that does not inform itself and portray contemporary news stories to the American public. So I just wanted to give a little baseline information here. First of all, we didn't disappear. We did not somehow vanish before the onslaught of manifest destiny. Today, there are 5.2 million Native Americans, according to the 2012 census. The Native Americans in our country or our indigenous peoples comprised of American Indians, Alaska Natives, and Native Hawaiians. And there are today 560 federally recognized Indian tribes by the United States government. There are 300 federally recognized tribes in the lower 48 states, including 11 here in the very proud and prominent Indian nations here in Wisconsin, 200 tribes that are recognized up in Alaska. These Indian nations maintain government-to-government relationships with the United States government in Washington, D.C. These are full-service governments that have lawmaking bodies, tribal courts, executive branches. They maintain police departments, fire departments. They own and operate colleges, museums. They're often the prime economic engines that fuel the local and regional economies where they are located. And as a matter of law, these 560 governments are an integral part of our domestic political system. The Supreme Court has defined them as domestic dependent nations that have a protectorate relationship with the United States government, in which the government has a trust obligation to look out for their best interests. The rights, relationships, and responsibilities among and between these 560 Indian nations and the United States government are defined by federal Indian law, the treaties, the federal statutes, the U.S. Supreme Court decisions. There are 369 treaties between the Indian nations and the United States government that were entered into by the United States government under the United States Constitution, that were negotiated by the President and the executive branch of the government, that were approved by a 2/3 vote of the Senate as required by the Constitution, which, according to the Supreme Court, these Indian treaties comprise the supreme law of the land. And we see our federal courts in the modern era breathing life into these documents and enforcing them just as any other treaty. That makes Native America and our Indian nations a unique segment of our diverse society, in that we are the only segment of American society that maintains a treaty relationship with the United States government. As far as land ownership, these 560 tribes own 100 million acres of Indian land today, Indian trust land that is held in trust by the United States government. There are 56 million of those acres in the lower 48 states and 44 million acres up in Alaska. This 100 million acres makes Native America as a whole the second largest landowners after the federal government in our country, and makes them as a whole the third largest owners of the minerals, the mineral resources of the United States. I could go on with the statistics about the land, but there's 44 million acres in range and grazing land, 2.5 million acres in cropland. There are tribes own 4% of our oil and gas reserves, 40% of our uranium deposits, 30% of our western coal reserves. As far as habitats, Native America tribes reside in some of the most awesome habitats in America, beginning at Martha's Vineyard in Massachusetts, the Wampanoags, who are called the people of the first sun because they are the easternmost peoples in our country, witnessing the rise of the sunrise before the rest of us. All across our nation, all the way out to Hawaii, who are the last to see the sun set. In between, our tribal peoples live in the Everglades, wetlands, the floor of the Grand Canyon. They occupy islands, mountains, the Great Plains, American deserts. They live in America's greatest rainforest in the Pacific Northwest, the Tongass rainforest in southeast Alaska. They reside in the circumpolar world. Most of America's remaining biodiversity is under native stewardship in our country, some of America's last best places. These diverse habitats have given rise to some very profound indigenous cultures, some very profound indigenous religions and religious practices that are tied to the land, and making a major contribution to the diversity of the American people. Springs from American soil from these indigenous habitats. The animals, the plants are truly part of these cultures here in our own land that makes America unique. As far as the socioeconomics, Our Native Americans live life at the bottom of virtually every socioeconomic indicator, be it life expectancy, major gaps in health care between Native and non-Native citizens, education achievement levels, unemployment rates, every socioeconomic indicator. We are the poorest of the poor in our nation. Politically, in the modern era of federal Indian law, from about 1970 to the present date, we have witnessed the tribal sovereignty movement in our country, where our Indian nations, with President Nixon announcing the historic Indian self-determination policy, it became the work of 2 generations of tribal leaders, tribal attorneys, Native Americans to implement this policy of Indian self-determination, to accord these tribes the right to determine their own destiny. We have witnessed one of America's great social movements that rivals the civil rights movement, that rivals the women's movement, that rivals the environmental movement as a great American social movement in the past 2 generations. And we've seen the rise of our modern Indian nations under this framework of federal Indian law. As I mentioned earlier, this legal framework of federal Indian law, it was derived by the Supreme Court from the early international law of colonialism. And to be fair, this framework, it has some very distinctive protective features in it. The inherent right of self-government, of inherent tribal sovereignty was recognized, the protectorate relationship between the tribes, the recognition of the treaties. These are protective features under which Native America has risen to our modern Indian nations today. But at the same time, just like any other legal framework, it's a man-made construct, therefore imperfect, and federal Indian law has a dark side to it. The principles that come from this early international law of colonialism included the doctrine of discovery, doctrine of conquest, doctrine of plenary power over the Indian nations, the doctrines of unfettered guardianship, judicial notions of race and racism that say, according to the Supreme Court decisions, that Indians are racially inferior. We have inferior cultures, inferior religions. A very kind of a dark side. After all, colonialism was an institution designed to appropriate native land and make the natives go away, to supplant them, to subjugate them. And the law of colonialism made everything perfectly legal. So there is this dark side, unlike Plessy v. Ferguson, which was the U.S. Supreme Court law that legalized segregation in 1896 through the separate but equal doctrine. That case, which brought rank injustice to Black America, was repealed and reversed by the Supreme Court in Brown v. Board of Education. Native people have many, many cases that rival Plessy v. Ferguson that have never been reversed. They're still the law of the land today. They're still relied upon by the Supreme Court to decide current day issues. So this dark side of the law that still sits before us clouds Native American rights. It makes all of the social advances made by our tribes vulnerable. And certainly we have a suffering from adverse judicial trends, in the U.S. Supreme Court today, all as a result of this dark side of the law. So this is just sort of a snapshot, I guess, baseline information about Native America. I want to turn now to defining human rights, which is a brand new idea for Native people, because as I mentioned earlier, the Supreme Court has told us that justice and morality there's no room for that in our legal framework. But what are human rights? We hear a lot about human rights today on TV. We read about human rights in the newspapers that mainly comes to us from the international realm, UN human rights treaties. I know that we deplore human rights violations in other countries. We're willing to go to war to punish those who violate human rights. We go to war to protect human rights. But really, what are human rights? And I know that many of the lawyers, U.S. lawyers such as myself, are simply domestic practitioners. We practice domestic law in our domestic courts. We don't go to Geneva, and not familiar with human rights parlance or practice. I would define human rights as simply the fundamental freedoms and rights that all human beings enjoy as a matter of right in the place in which they live. And the contents of human rights, the substantive content, is defined and elaborated upon in international law by the norms in customary international law and in the human rights treaties. This, as I mentioned earlier, is a rapidly growing body of law. But to many Americans, human rights may seem alien at first blush, but on a second look, I think we'll quickly see that human rights are uniquely an American concept. Human rights are as American as apple pie, because here in the United States, we have a splendid human right heritage in our long and proud history that I think defines us as a people, as a diverse society. Our nation was literally birthed by the proposition that each person is endowed by certain inalienable rights, rights that come to us from a higher source, rights that all governments were formed to protect. So these kinds of rights have been variously described as natural rights, the sacred rights of mankind, and these concepts, these natural law concepts, were well understood, by the founding fathers of the United States. The American Revolution arose because of the denial of human rights by Britain. So ours was a human right revolution. And these human right precepts that were written into the Declaration of Independence, which I'm going to quote here, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among them are life, liberty, and the pursuit of happiness, that to pursue these rights, governments are instituted among men, deriving their just powers from the consent of the governed. These principles animated our nation from the very beginning. They were written not only in the Declaration of Independence, but into our Constitution, into our Bill of Rights. These precepts and principles were on the lips of the people during the rise and growth of our democracy at every important juncture. And it's true, you know, we haven't always lived up to these core American values. They were certainly impugned by slavery. They were contradicted by the inequality for women and undermined by systematic discrimination against minorities in the history of our country. But in each of these instances, our core values impelled Americans to self-correct. And that has led to unprecedented freedom in our land, you know. So we have these core human right values that define us as a diverse people. But as I mentioned earlier, human rights for Native Americans is sort of a new and, I guess, radical kind of a concept, because the Supreme Court has said it has no, justice and morality has no place in defining the rights of our indigenous peoples. And federal Indian law is bereft of the human right principle. You read our cases, and there's hundreds of Supreme Court decisions. You will find no judicial discourse on human rights for Native people. You'll see no human right principles or precepts in these cases because they were expressly eschewed by the U.S. Supreme Court. But now, as I mentioned earlier, for the first time in Native American history, we can see way out on the horizon a brand new human right framework coming our way. It's kind of like a spotted horse that you see out on the horizon, and we know it's bringing good things to our people. So I just want to move on here to the Native American human rights experience that I've alluded to here earlier. In the history of our country, indigenous peoples in the United States, we didn't face slavery and its troubling aftermath, you know, like Black America did. But we faced an equally egregious human rights situation. The legacy of conquest and colonialism. It's very well known in American history that the settlement of our nation had very harsh impacts on our Indian nations, marked by invasion, warfare. Our history records more than 40 wars over a 100-year period between the United States and our Indian nations. During the 1850s through the 90s, most of our country in the American West was one vast theater of war. It was marked by the appropriation of tribal land, such that by 1960, we had less than 2% of our original land base left. It was marked by disease brought by European settlers. Smallpox decimated my tribe again and again and again in the 1830s. It was marked by habitat destruction, loss of culture, enforced assimilation, and all of these adverse, traumatic, cataclysmic experiences were deemed to be perfectly legal by federal Indian law principles. And by the 1950s and 60s, these effects were still very clearly seen, leaving imprints, in our legal system, leaving imprints in our traumatized tribal communities, and implanted into the dark side of federal Indian law by these nefarious notions from colonialism that I mentioned earlier. In the modern era of federal Indian law, beginning in the 1970s with President Nixon's self-determination policy, Native America sought to redress these lingering ill effects of the legacy of conquest and colonialism. Through this tribal sovereignty movement that I mentioned to you, all of the Native peoples worked to implement the self-determination policy to empower our tribal governments, breathe life back into our treaties, fight for the cultural integrity of our peoples, to get space for our Indian nations to live and prosper. We've come a long way, I think, to our credit under an imperfect legal framework that is bereft of the human right principle. But I feel as a longtime practitioner of federal Indian law that our progress has kind of stalled out in the last decade or so. We have an 80% loss rate before the U.S. Supreme Court, which is on a conservative tilt towards trimming back our hard-won rights since about 1985. And this 80% loss rate means that Indian nations lose more cases or fare worse than prison inmates before the Supreme Court. So I feel that we have come about as far as we can go in Native America to reach our aspirations under this existing framework. The axiom here is that a race of people can only go so far in their aspirations under an unjust legal framework. And to advance any further in their aspirations, at some point in history, they have to reform that legal framework and remove the unjust features. And I think Native America stands at that crossroad today in terms of their number one paramount challenge, to protect the advances that were made in the past 2 generations, to get a stronger legal framework that's more reliable. Today is a very exciting time now with the advent of this UN Declaration on the Rights of Indigenous Peoples. This creates a brand new, comprehensive, standalone legal framework for defining the rights of Indigenous peoples worldwide, including in Native America. At the heart of it is the Indigenous human right of self-determination, which is consistent with the U.S. policy since 1970. It talks about self-government as an inalienable human right. Indigenous institutions, it talks about our land rights, our habitat rights as human rights, our political participation in the larger society as a human right, very strong rights of culture, rights of religious freedom, language rights, our education rights, our rights in the public media, health, our treaty rights. Just as a quick example, Article 13 on education it lays out 3 human right principles here. First is the inherent human right of Native Americans or indigenous peoples to establish and control their own educational systems in our own language and taught through culturally appropriate methods as a human right. Secondly, it includes equal education opportunity to all levels of education without discrimination as a human right, as a matter of human right under international law. And thirdly, it imposes an obligation upon the United States to take effective measures in partnership with indigenous peoples to educate indigenous peoples in their own culture, provided to them in their own language. So, and this is fairly similar to the Wisconsin Act 31, which was enacted here in the great state of Wisconsin, that requires the teaching of Indian culture at all grade levels in our public schools. So this would expand and elaborate on that, supplement it, and say, yes, also as a matter of inalienable human rights. So the challenge as I begin winding down my remarks, 5 minutes worth here, is to implement these provisions, which will require a sea change in the way that Congress, the courts, and the president look at Native Americans in the USA today, in the way that our state governments look at Native people today through a human rights lens. And what could be stronger, what could be more just set of values than human rights? The notions of justice, notions of goodwill, notions of democracy. These are the kinds of values that give rise to human rights, something that our nation is very, very familiar with. So I think the implementation of these human rights principles is going to be the work of a generation. Our Native peoples, who are less than 2% of our population, are going to need help. The UN says that this should be done in consultation and partnership. The government needs to provide technical assistance and even funding to Native people to begin this process of nation building so that we can complete the final chapter of the American Revolution by bringing Native people within our human rights ambit here. And we stand at the dawn of that, at the foot of a large mountain. What can colleges do along the way to help, I have a few quick thoughts here, but first of all, to teach the human rights experience of Native Americans to your students so that everyone will know the real history of this country. Secondly, to teach students in law schools and the undergraduate levels the language of human rights, the language and parlance of human rights. To maybe each generation of Americans have had to learn or relearn our core values. And this is a human rights discourse. And then to support our Native American students that have the good fortune to come to this campus, to provide them with the support system, with the culturally appropriate curriculum, to enable them to be a success, that they can go forth and have a long and productive career in whatever field that they so choose, because the education is so critical to the success of our Native peoples, and have enabled people like me to go a long ways towards serving the needs of our communities, that we might not only survive but attempt to prosper, in our own land here. I would urge, that we support our Native students that come to this university. It's a privilege accorded to only, not all people, but once the students get here, help them along the way. Colleges can also foster a public discourse that I think will be important here. What is human rights for Native people? What is the substance and the content of human rights for Native Americans? Our nation has never engaged in a discourse of that nature in the same way we've considered the problem of slavery and that troubling aftermath, And I think America is reluctant to look at its legacy of conquest and colonialism and the manner in which the Native people were treated, because it impugns our self-image. It impugns our core values, And sometimes it's hard to face our inner demons, but we have to be able to have a discourse here on human rights for our Native people, something that has never happened before. And I think our scholars can contribute to a body of human rights literature regarding this UN declaration. So there's a lot, I think, of leadership and work that could be done under the name of diversity and inclusion to help our Native peoples, enter into the human right era here in our own country. And I feel it's important that we do so the way that America treats its own Native peoples, sends a signal to the rest of the world about our commitment to human rights, which has always been important in our foreign policy. And so what we do here in our own backyard, I think, is relevant to the well-being of Indigenous peoples around the world. And so with that, all of these points that I've made are elaborated on in my book, which will be provided by the university here afterwards. I don't know what room it's going to be. That away, okay. And I'd be very pleased to sign an autograph for you, that book. But it's being used as a textbook in many colleges and law schools around the country as we begin to wrap our arms around the human rights for Native peoples. It discusses the content of human rights under this declaration. It compares it with our existing human rights, existing federal Indian law to identify areas of short failings, and it talks about the elements for a march to Indigenous justice. So with that, Provost, Vice Provost, again, I commend you for bringing this fine group of scholars and the best and brightest minds, to focus on diversity for a couple days here. That is so important to our society, and I give you my well wishes over to the rest of today and tomorrow as we gather together at this conference. I pray that the Great Spirit will be with you in all of your endeavors, and God bless each and every one of you. So.
Don't go too far. We're slated to wrap this portion up at 10:15. We know this is the segment where we wanted to create an opportunity for individuals in the audience to ask questions of our keynote. As he mentioned, He will be available at 10:15 to sign in the lobby if you're interested in purchasing the book. The book signing is hosted by our partner, Mystery to Me Bookstore, so I wanted to acknowledge them and thank them for their great support for being with us this morning. And thank you again so much, Walter Echohawk, for your comments and insights. Appreciate it. So if you have questions, we would ask that you please come to the microphones and use the microphones, and we will form a line and we'll sort of alternate from either side, and we'll try to take as many as we can before 10:15. Thank you.
As long as the questions are easy ones. Oh, okay. Sir.
I'm Ben Marquez. I'm a professor of political science, and I'm also the director of the Chicano Latino Studies program. And I loved your talk. I thought it was really fabulous. But I wanted to ask you about the UN Declaration on Indigenous Rights and its implementation. Should it be implemented in the United States, what would be the implications for Latinos in the United States, who, after all, are, part indigenous, but part settler as well? I wonder if there would be any spillover, or if this would just be a discrete action or law, or set of laws.
That's a very good question, whether this UN declaration would apply to Latinos in our country here. The UN Declaration does not define indigenous peoples. There's no definition in it. Nor is there a bright line definition of indigenous peoples in international law. But a lot of the scholars basically define indigenous peoples as native or tribal people that resided in a land that was colonized by Europeans. That were there basically before the colonists arrived, that identify themselves as indigenous peoples, that have a unique cultures and language, and a few other attributes. Certainly the Latino population here would be indigenous under that definition to the lands where they originated from, but possibly not necessarily indigenous to the United States. Just like if I were to move to Europe, I would not be indigenous to Europe, but indigenous to the U.S. here, provided they identify as indigenous peoples. Sometimes we've seen that many have been detribalized, that they might be a full-blooded Indio from Mexico, but have become assimilated, that maybe they speak Spanish, they think they're Spaniards or something, but they're biologically indigenous, and the question is whether they identify as such, so. But it's a sort of an open question, because the Declaration itself does not define that term. I think it just leaves it to general notions of parlance, I guess, in international law for that. So, yeah.
Thank you for your talk. I'm just trying to get a better understanding of what the full implications of this new UN human rights, what this new framework is. So I wonder if you could give an example of a case that has come up that would be determined differently under this new framework, that had a different outcome under this new framework versus what would have been available under pre-existing law.
I'm sorry, I'm not sure I caught the question again. I have to say I woke up, as I mentioned to the Vice Provost, I woke up one night and my hearing was gone in my right ear, and I'm slated for surgery. But so I'm sorry, could you speak up and repeat, please?
Sure. Sorry about that. Can you hear me better now?
Yeah, okay.
All right. I'm trying to understand the real implications of this new framework. So I'm wondering if you can give an example of a case that had a different outcome because of this new framework of law that would not have had this outcome under the pre-existing
Yes,
law?
yes. Well, 2 points. First of all, as a declaration in international law, this is not like a signed treaty that's binding that federal judges have to enforce. But as a declaration, it's simply a statement of aspirations and policies, even though it contains the same language as our UN human rights treaties, to which the U.S. is a party, and incorporates well-settled norms in customary international law, which become a part of our federal common law. It encourages nations to actually implement these standards in a proactive process in partnership with Native people. And if they were implemented, the impact would be to erase and to reverse the dark side of federal Indian law and to replace these nefarious legal principles that don't pass muster with these human right principles with human rights. So that, for example, the foundational case of Johnson versus McIntosh, decided by the Supreme Court in 1823 by the Marshall Court, John Marshall being the most famous Chief Justice of the United States Supreme Court ever, kind of like Elvis. He, in that case, was confronted with the nature of land title of our Indian nations. Of course, we own the continent. And the question came to his court, well, what is the nature of Indian title? Can they sell land to non-Indians? And he said no. He said that he imported the doctrine of discovery from international law, which says that when a European sailor saw the American coastline, that act of discovery operated to transfer legal title to Spain, and then, or to England, I guess, and then on to the United States as the successor in interest to England. Well, that's a legal fiction. It converted the tribal nation landowners from a landowner to a tenant of the federal government by a principle in international law, this law of discovery. And he added to it the doctrine of conquest. He also said that act of viewing that coastline was tantamount to conquering the continent, even though no bullet had ever been fired. None of those then he bolstered it by saying that the tribes have an inferior religions, they're savages, they are inferior race of people, their cultures are very primitive and all this sort of thing. The notions of, these are all discriminatory notions that are thrown out the window in the Declaration, which insists upon equality. And it defines land rights, the inherent right to own land, which is a norm in customary international law, to own land and not to be stripping it away, converting it into a tenet of the government. So that would, these principles would effectively overturn Johnson v. McIntosh and its progeny, and replace it with a strong, vibrant land ownership rights. So that's just one example. And I could go on and on. I've written another book called "In the Courts of the Conqueror: The 10 Worst Indian Cases Ever Decided." And each and every one of those cases espouse legal doctrines and holdings that don't comport with these minimum standards. So if our nation and our courts and the Congress adopted these new intervening legal principles, the impact would be to overturn the dark side of federal Indian law. so that we would no longer have to live under the cloud of our Plessy v. Ferguson cases that we are still the law of the land today. Mr. Birdbear, or, okay. Oh, sir.
Thank you. So I'm thinking about the psycho and social health of our First Nation students here. And I'm thinking about this amongst the community of folks who will be interacting with the students. And since you brought up, of course, the topic human rights, and I think about the work that Dr. Joy DeGruy did around issues of post-traumatic slave syndrome in the African-American community. And I'm wondering if there's something comparable when I think about multi-generational trauma as well, and what you think may be, we may be changing laws, we may be conscious of this, but not thinking about that trauma that remains.
Yes, there's something very comparable to post-traumatic stress syndrome, historical trauma that is a very commonly seen feature in many tribal communities today. My book, In the Light of Justice, that will be out in the hallway here, talks about that. And it illustrates the need to implement these standards as a way to redress and heal a very painful past between the conqueror and the conquered. And a lot of our tribal communities carry all of the indicia and characteristics of a highly traumatized history, one cataclysmic event after another. And so we see that these hard-to-solve social ills that are seen in our tribal communities are the end products of history of colonialism and conquest. And how do you go about restorative justice, for such communities of that nature? How do you heal a painful past, and I think that the restoration of human rights, we know we can't turn back the clock, but I think that under principles of atonement, we must do, when we have brought an injury to someone, principles of atonement in all religions of the world say you must go to that person and apologize. And if that person accepts your apology, then you must do acts of atonement to try to wipe the slate clean as best that we can through concrete acts, with the goal of trying to bring about a reconciliation, to make peace, to restore harmony, And so that's what this process of implementing these human rights standards would do, to bring about a healing. Often in remedial justice, it's the not necessarily the remedy that's important, but many times it's the process in which you follow to achieve justice, is just as important as the end result, And so this implementation of this declaration is seen by international law experts as a nation-building reconciliation process in about 90 countries that were engulfed by colonialism, that to rid the lingering ill effects of that traumatic history, and to bring about a reconciliation, a stronger nation as a result of meting out justice and harmony in these 90 nations around the world that have 350 million indigenous peoples. So I've spent about a chapter on that very question that you posed, on that, which is a very apt question. Thank you. Mr. Birdbear.
Our institution is engaged in a process of educating the public and the student body about the contest for this space, the depth of humanity that's here on these lake shores. And since we haven't gone through any truth or reconciliation process as a state or institution, we're discovering just how much trauma is within these communities as we ask them to kind of share at this point in time. So we recognize a process of kind of decolonizing methodologies where we got to honor the trauma and the grief and the frustration of the Native nations, have a kind of private healing space for them, and be open to continuous negotiation as we think about sharing, like what kind of shared stories we can create and learn from each other. So my question is, how is in this march toward Indigenous justice, how important is it for a Research One university to have like a land acknowledgement statement, or to kind of have some sort of established process of truth and reconciliation in that our institution, our state, and the US government hasn't really engaged in these types of processes formally yet? So in terms of a land acknowledgement statement or some sort of open and defined process for kind of truth and reconciliation between a Research One university and the Native nations within its state.
Yes, well, as I mentioned, I think that all universities, especially very prestigious institutions such as this one of higher education, have a pivotal role to play, in the process of bringing about a reconciliation through carrying out their higher education functions, in a way that promotes the discourse that involves the indigenous tribes of the area, and not only trains our young people in all areas, but equips them or arms them with the language of human rights and taking a proactive justice stance, So I think there's a lot of things that can be done in the area of scholarship, generating white papers on the subject of justice or indigenous justice, maybe forming a committee on this subject, to better flesh out. I'm not a higher education expert, but I'm sure you can think of many more activities of goodwill that would fall within your mission that could be done to assist our indigenous peoples, in obtaining the full measure of their human rights as defined by international law. Thank you.
In the interest of time, we're right at 10:10, but we have 3 people here, so they've been patient. I would like for you each to ask your question, and then that way, if you can combine your responses to the respective questions, we'll be able to end right at 10:15, the way we're supposed to.
So you voiced hope for a significant and profound change in the way Native people are treated in this country. And it's interesting to me that you see that hope just in a time when so many people see nothing but regression of whatever progress there has been. Of course, on the federal level, I don't need to discuss that. Also on the state level, just today, a package of laws is going to pass, allowing, for example, for mining to start and for corporations to not be responsible for the damage that they cause. And so I just wonder where you find that hope, and how can you maybe infect us with it? And thank you. If you can answer that in just a couple sentences, I have to go prepare for a workshop that I'm leading. So, sorry. Thank you.
Thank you. As I mentioned, human rights are as American as apple pie, and we've seen social justice movements in our American history use strategic law development as a tool to march forward at kind of a methodology that works in even the most oppressive situations. I think a lot of the social change that is going to be necessary along the way will emanate from a grassroots level. The state of Maine, for example, legislature passed a resolution endorsing this declaration. It's something that the Wisconsin could do. I think Illinois may be another candidate for legislating in this area. And ultimately, once we get some grown-ups in Congress, maybe we could even see our Congress step into the picture. But I think there's a lot, this is a long-term, as I mentioned, effort. It's going to be the work of a generation. It's going to take place and go beyond the present administration. It took the NAACP Defense Fund, which was founded in 1910, 58 years to overturn the Plessy decision, which was handed down in 1896, all the way to 1954 in Brown v. Board of Education. And so these efforts, you know, nothing is easy in the area of justice, you know, because these human rights are never freely given. They must be demanded, wrested away, and then vigilantly protected. And that's the essence of freedom, you know. So I'm very optimistic that this can be done because Americans, once they have been informed, in my experience, are a very just people and have invariably act to do the right thing. And I think it's in large measure a public education task, you know, to which universities can certainly have a seat at the table.
So my apologies. I'm going to have to stop the questions right here. First off, a round of applause for our keynote speaker. What I can say for those two who are waiting, maybe if you want to be first in line when he gets ready to sign the books, that perhaps can be a compromise there. I would be remiss if I didn't take this opportunity to acknowledge our sponsors, our co-sponsors. We want to acknowledge the School of Business, who helped fund Mr. Echohawk's visit with us, and also acknowledge American Family Insurance, who's also one of our keynote co-sponsors as well. Thank you so much, ladies and gentlemen, for being with us this morning, and I hope you hang around and enjoy the rest of the day. There's an amazing series of sessions and breakout discussions that are available. You can join us back for lunch, and we'll talk about the Campus Climate Survey results, and of course, we'll be looking forward to seeing you at the Town Hall event. Enjoy the rest of the experience. Have a good one.